Mayaro. I'm a solicitor at Tanlo Solicitors, based in the United Kingdom in Coventry City. I'm here again for our weekly on legal updates. The first update that I have for you is that the priority service for visa submit in again. Some visa routes now have priority service. The priority service allows you to receive a decision in most decisions which are eligible. It had been suspended because of COVID, but now as we are getting out of downs, the priority service is coming back into play. So if you want to receive your decision earlier than normal, you need £800, and then you should be able to get your decision earlier than normal. I've just done an application today online, £800 additional fee, and you can be able to get your decision earlier than is usual. So that's the first update that I have. The second update and an encouragement is that those people who have got relatives or who are EU nationals themselves should consider the fact that the 31st of June is just but an EU passport, or if you're an EU national and you've got a family member that you want to bring to the United Kingdom, this is the high time that you have to consider your options that are available for EU nationals and their families. And each option might depend on the circumstances of that particular individual. Large, most of the applications, the deadline would be the 31st of June for you to make an application. And some of them the deadlines might go beyond 21, depending on the route for the EU national. The EU regulations and appendix, so they're now an appendix in the immigration rules, but it is important to just note that if someone is within the United Kingdom, they've got an pre-settled status under the EU settlement scheme or the settled status. If someone has been in with a provable track record as a qualifying person, and the qualifying person includes people like a student, self-employed, an employed person, a business person, has got adequate resources to look after themselves, and has got adequate health care, insurance, those are qualified people. And if they've got a family member, then their family can get a permit under EU provisions. So if you have been in the United Kingdom for more than 5 years, then you might qualify, or you will qualify for settled status. If you have been in the United Kingdom for less than 5 years, then you will get what is called pre-settled status end of June. The application can be done online. You go onto the gov.uk website, you enter your details in there, mainly your family details if you are a family member, and then you make the application, and 9 out of 10 times it should be successful with your NI number, which the Home Office can then use to track your NI contributions, or at least your link with the W and P and the HMRCE. So this is available to people who have families. If you are outside the country, or if you have been in the UK and you went outside the country, then in EU country and you've got an EU national, you need to consider as well. There's varying deadlines, but it's best to make your inquiries before the 31st of June in 2021 in case you will miss vacation. For British nationalities that are based outside the UK, in the EU, you can also make an application, what is normally called the Surinder Singh route, whereby you have stayed at least 3 months outside of the UK with your partner or a wife, and then you want to bring or husband, and you want to bring them over to the United Kingdom. So the Surinder Singh route is still available. You can make an application, and for those people who are British citizens and are in EU, and you have been in a relationship with your partner prior to the 31st of December 2020, you have around March 2022 to submit your application. Otherwise, it will be the usual deadlines that are there. So this application, the advantages of making an application as an EU national or under the Surinder Singh route is that there is no need to prove any income application fee. That's the first point. And then number two, you are not required to prove your income. And number three, you don't have to pay for the IHS. So it is important, if you qualify under this route, to take action as soon as possible. Tanlo Solicitors is there to help you with any applications that you want to, routes that might be available. So that is my update on immigration for this week. If you've got any questions, you can contact me. My name is Andrew Nyamayaro. I'm a solicitor at Tanlo Solicitors. We are based in Coventry, the United Kingdom. Our phone number is 02477632323, and our email is info@co.uk. You can get me on WhatsApp as well. The WhatsApp number with the international code is 004421429338. Or you can visit our website www.tanlo. The other issue that I just want to touch on briefly is the issue of enforcement of foreign orders. I have clients that from all over the world and indeed all over the UK, and sometimes I do deal with cases whereby it's across different jurisdictions. The client might be based in the United Kingdom but has got properties somewhere in Africa or in America, or it is not always that if an order is granted in one jurisdiction, then it is automatically enforced in another foreign jurisdiction. Enforceable where there is a mutual agreement, or where there is a reciprocating arrangement between the countries, reciprocating arrangements or a mutual agreement between the countries, then a foreign or international order is not enforceable. To be specific, if you are and you get a court order in the United Kingdom and you want to enforce it in Zimbabwe, it might not be necessarily be enforceable by and large. If you get, for example, a divorce order, you then need to take it to the international country or to Zimbabwe. Then you have to go to the High Court and register through the processes and the procedures of Zimbabwe. When it comes to maintenance cases, there is a reciprocating agreement between countries, and which is commonly known as REMO, REMO, if you want to search for it. And Zimbabwe is on the list of reciprocating countries. So a maintenance order that is made in the United Kingdom is enforceable in Zimbabwe, for example. So you can just do the deputy sheriff or whoever does the process serving in Zimbabwe, and they'll be able to enforce this order on your behalf. Some of the orders that people normally get from this side, which might need to be recognized in Zimbabwe, will be divorce orders. So if you get a divorce order, you're absolute. You have to get it to a court in Zimbabwe so that it can follow the formal channels in Zimbabwe for it to be recognized. If you get a financial order from the United Kingdom, whereby there is an order of how the properties is going to be distributed or dealt with, you have divorced, then you might need to register it again with the authorities or the courts in Zimbabwe. The other issue that I normally get is the issue of wills. People always ask me, should I get one will that covers my properties in all the countries in the United Kingdom, Dubai, and so forth? Whilst it might be possible to have one will covering all of your properties, the main challenge is that these countries have different procedures. So it is advisable for you to have maybe multiple wills, which can be enforceable in different jurisdictions, reference to each other, so that it can be known that these wills coexist together, and they refer to properties in each country, which is the person that will be handling your documents must have all of your wills that you have. Again, at Tan Law Solicitors, we do help you with divorce, child arrangements, enforcement, restraint orders, financial orders, and so forth. We can help drafting of wills and enforcement of wills, assisting executors and administrators. We can help you with that. You can get in touch. You can just put our name in any search engine, and you should be able to get our details there. My name is Andrew Nyamaharo, and our phone number 02477632323. WhatsApp 0044142938. Thank you, and see you again next week.